All right, let's just dive right in because we need to talk about a hard truth facing the legal world in 2026. Oral advocacy has completely transformed. And it doesn't matter if you're in a physical courtroom or logged into some high-def neural interface, your power to persuade, it's just not about knowing the law anymore. It's about mastering the medium itself.
And that brings us to this pretty provocative idea. The gift of gab? It's dead. In fact, relying on those old-school traditional oratory skills can actually be a liability now. The old theatrics of the courtroom are just gone. Today, it is all about being precise, strategic, and in total command of a completely new set of tools. So, what's driving all this change? What's behind this new reality? Well, it all kicks off with a problem of scale that is, frankly, almost impossible to wrap your head around. Just take a look at this. In Brazil, their Superior Tribunal of Justiça started 2025 with nearly 360,000 cases on the docket. Think about that. That's a new case being filed every minute and a half. This kind of overwhelming pressure forces the courts to adapt, to bring in new systems like AI filtering and virtual hearings, really just to keep functioning. And here's something you absolutely have to know. Not all of these new courtrooms are the same. It is critical to know the difference between a synchronous session, which is basically a live, real-time hearing, and an asynchronous one where you just submit a pre-recorded video. Mistaking one for the other isn't just a small slip-up, it's a fatal strategic error. Okay, so how do you even begin to navigate this high-pressure, digital-first environment? Well, the answer lies in a totally new framework. This is what we call the Trinity of Modern Persuasion. You see, the Sovereign Counsel, the true master advocate of 2026, builds their case on three core pillars. First, mastering your virtual presence. Second, understanding the cognitive psychology of the modern judge and juror. And third, applying a kind of surgical impact rhetoric. Today, we're going to dig deep into those first two. So let's start with your presence. A lot of advocates treat a virtual hearing like it's just a convenience. They are so wrong. It's a digital stage, and your credibility is on trial from the very second you appear on that screen. So this all boils down to a concept called digital ethos. In classical rhetoric, right, ethos is your character, your credibility, while in a virtual court, your ethos is established by your technical command of the medium. I'm serious. Your lighting, your camera framing, your sound quality. These are the new foundations of trust. Now, let's get into the mechanics here. To create that direct gaze effect that builds trust, you have got to look directly into the camera lens, not at the faces on your monitor. Frame yourself from the mid-chest up. So why does that matter? It's biology. Our primitive brain is hardwired to distrust hidden hands. When you gesture within the frame, you're subconsciously signaling that you're transparent and confident. And this perfectly illustrates the next point. In 2026, think of it this way. Your audio quality is the new silk tie. If your voice is thin, distorted, or has an echo, your argument just loses all its weight. A stable, resonant voice becomes your anchor of authority in a sea of digital noise. We call this technique vocal grounding. By speaking from your diaphragm, you produce a lower, more resonant frequency, a tone that the human brain automatically associates with leadership and stability. And remember this, use strategic 2-second pauses. This isn't just for dramatic effect, it allows for digital lag, and it gives the judge's brain time to actually process what you just said. Okay, let's move on to this second pillar, because this is where it all comes together. Once you've mastered the stage, you have to master the mind of your audience. The 2026 juror is a digital native, and believe me, their brain is wired differently. You are operating in an attentional economy. The days of long 2-hour opening statements are over. You have about 60 seconds, 1 minute. That's your window to hook your audience. If you fail in that first minute, you've probably lost the case before you've even presented a single piece of evidence. And this is all because of something called cognitive load theory. Think of the brain like a computer with limited processing power. When you overwhelm it with facts and clauses and data, it just simplifies, or even worse, discards the information. So the goal of modern persuasion isn't to be the most comprehensive anymore, it's to be the easiest to process. So how do you do that? Here's the secret. You don't start with the facts. You start by giving them the lens through which they're going to see all the facts. It's a technique called priming. You're telling them how to interpret the information before they even get it. And this shows you exactly how it works. Let's say you have a really complex contract breach case. Instead of starting with Article 5, Clause 2, You frame the entire case with a simple, powerful lens, a broken promise. That's a universal human concept. Now, every single piece of evidence you present gets automatically filtered through that moral idea, making your argument feel intuitive and way more compelling. Which leaves us with one final question to think about. In this new era, your role has fundamentally changed. Are you merely an expert in the law, or are you becoming something more, an architect of human perception itself? That is the challenge and the real opportunity of 2026.
Let's talk about the courtroom of 2026. Do you think the art of persuasion is the same as it was? Not even close. It's not just about knowing the law anymore. It's about mastering a whole new digital world. So let's dive into what it really takes to dominate in this new era. I want to kick things off with a pretty bold statement. The gift of gab is dead. You know that classic image of a charismatic lawyer winning over a courtroom with just a booming voice and a flair for the dramatic? Well, that's officially a relic. In today's high-tech, high-volume courts, a new, much more precise kind of persuasion is absolutely essential. And look, this shift isn't just about style. It's being driven by pure necessity. Just take a look at Brazil's Superior Court of Justice. In early 2025, they were facing a backlog of nearly 360,000 cases. That is staggering. A system under that kind of pressure doesn't just evolve. No, it's forced into a revolution. So all of this brings us right to our first section. We are living in a new judicial reality, one where technology and just sheer case volume are completely reshaping the courts as we know them. Now here's something you've absolutely got to get. Not all virtual hearings are created equal. In Brazil, for instance, there's a huge difference between a sessão telepresencial, that's a live hearing, think Zoom, and a plenário virtual, which is where you submit pre-recorded arguments. They are totally different beasts, and if you use the wrong strategy for the wrong one, you could tank your case before you even start. And here's where it gets really disruptive. With over 60% of courts already using AI, your first audience, it might not even be human. This means we have a whole new skill set we need to master. Language engineering. You're not just writing for a judge anymore, you are drafting arguments for an algorithm that filters, summarizes, and ranks your case before a human ever lays eyes on it. So you see, in this new reality, this high-volume, AI-filtered environment, the old playbook is it's obsolete. To cut through all that noise, you need a completely new framework. And that framework? Well, that's what we're going to call the trinity of modern persuasion. These are the three core pillars you need to build your advocacy on. So what are they? First, there's digital presence, mastering that virtual stage. Second is cognitive architecture, engineering how your argument is actually processed in someone's mind. And third, impact rhetoric. Now for today, we're going to build the foundation by really zeroing in on those first two. All right, let's dive into Pillar 1, digital presence. You know, a lot of people treat a virtual hearing like a simple conference call. That is a huge mistake. It's a stage. And believe me, your credibility is being judged on your technical presentation before you even say a single word. This all boils down to a concept we can call digital ethos. You know, in classical rhetoric, ethos is all about your credibility, your character. Well, in a virtual court, that credibility is established by your tech setup. It's your lighting, your framing, and your eyeline that build your authority from second one. Okay, so let's get tactical. How do you do it? To create what's called a direct gaze effect, which builds trust, you have to look into the camera lens, not at their picture on the screen. Frame yourself from the mid-chest up. Why? So your hands are visible. Our brains are literally hardwired to be suspicious of hidden hands. And, of course, good lighting from the front, that's non-negotiable. Okay, so your visuals are locked in, but what about what they hear? Let me put it this way. In 2026, audio clarity is the new silk tie. If your voice is thin or distorted or echoing all over the place, your argument, no matter how brilliant, just loses all of its weight. And the technique to achieve that powerful audio is called vocal grounding. It's all about speaking from your diaphragm to create this stable, lower frequency tone. You see, subconsciously, we associate lower vocal tones with leadership and stability. In a world full of digital noise, a grounded voice becomes an anchor of authority. Okay, so you've absolutely mastered your digital presence. That's half the battle. Now for Pillar 2, cognitive architecture. How do we actually win inside the mind of the modern, completely distracted juror or judge? First things first, we have to accept that we're operating in what's called an attentional economy.
The morning brain it's wired for high-speed information. You're not just arguing a case, you are competing for a very limited resource, their attention. The days of long, winding opening statements, they are gone. Forever. And if you think I'm exaggerating, just look at the data. It's brutal. You have their maximum attention, 100%, for about the first 60 seconds. After that, it falls off a cliff to less than 40%. If you haven't hooked them in that first minute, you've probably already lost. So how do we hook them? Well, it comes down to understanding something called cognitive load theory. See, the human brain has a finite amount of processing power. When you hit it with too much complex information, it doesn't try harder, it just simplifies. Or worse, it just discards the data. Your job is to reduce the friction of your argument.
And the tool we use for this is the persuasive funnel. So instead of just dumping a ton of complex inputs on them, like facts, contract clauses, timelines, you first pass all of that information through what we call the lens. The lens is a simple, powerful, moral frame that tells the listener how to interpret everything that follows. That way, you control the output, the simple, memorable takeaway you want them to have.
Let me make this really concrete for you. Imagine a breach of contract case. Don't you dare start with clause 7, subparagraph B. That is pure friction. Instead, frame the entire case through the lens of a broken promise. It's a universal concept everyone gets. Once you activate that frame, every single fact you present from then on is automatically filtered through that powerful moral idea. You've literally engineered their takeaway.
So I'll leave you with this question. Your facts might be solid. Your legal reasoning could be flawless. But in 2026, if you haven't mastered your digital presence and engineered the cognitive architecture of your argument, is the very medium you're forced to use now becoming your biggest liability? That's the challenge every modern advocate has to face.